This is Hidden Killers Week in Review.
A look back at the most prolific stories of the week.
This is the Hidden Killers podcast with Tony Brueski.
Featuring defense attorney, Hidden Killers daily contributor, and host of the Defense Diaries podcast, Bob Motta.
When it comes down to the Sixth Amendment being violated in this whole thing, with the fact that they did come back and say, hey, we're going to do this pro bono, then it goes over to be the category of attorneys of choice, rather than just being who's assigned. Is there anything that prevents anyone in any case that you get assigned your attorney? Let's say suddenly you come across some money. Maybe a family member steps in and says, we can do better. Let's pay for some defense here. Obviously, that's not what happened here, but pro bono, he's getting this for free.
But it is. Forget the money side.
I mean, take it out of it. Is there anything that prevents that from happening? That's the weird thing to me. It's like, well, okay, if they're going to do it, he could represent himself if he wanted to and go up there. The judge can't say, sir, you can't represent yourself. You have no defense now. He could do that just as easily as he could say, hey, they're going to do this for free. Cool. I don't get where she can step in and still say, no, you still can't have these people. That just doesn't seem to make any legal sense at all, other than
it's crazy. But like, keep the money side of it in or out. It doesn't matter. The fact of the matter is, like, it happens constantly, all the time. I mean, if I have somebody that comes into my office and they're like, oh, we'd really like you to represent us in this case. And we're like, okay, well, this is what our retainer amount is. They're like, whoa, well, we don't have that kind of money. And I'm like, well, here's what you do. I'm like, just go with the PD. Your case is going to take quite a period of time. You're not in custody. Just try to save up some dough. Go with the PD for the first 6, 7, 8 months while you're saving money, and then just come and retain us. It happens all the time.
Yeah.
All the time. There is not, like, ultimately, as long as you have a replacement for the public, for the appointed person, the defendant has the right to say, because like a defendant can't just run through public defenders.
No.
Saying, oh, I don't like this guy. I don't like this woman. I don't like this guy. Like, I mean, I've seen it happen in some cases, like that Sarah Boone case, the woman who zipped her boyfriend up in the suitcase and forgot about him allegedly. Yeah. Like, she's gone through like 7 lawyers. Like, and I don't even know how that's happened, but I mean, it's very, very common for somebody to start off with a PD, and then exactly like you said, that family, friends, whoever raises the capital to get them private counsel. Yeah. And like, the fact of the matter is the issue with public defenders is not their ability to practice law. There are brilliant public defenders out there. The problem with public defenders is their caseload. I mean, they just do not have the amount of time that a private attorney will have. Sure. In order to dedicate to that case. So that's why it's always going to make the defendant feel more confident in their private counsel, because they just know that the attorney is going to have more time to deal with their case, and they'll just get more attention from their attorney than they will with the PD. Yeah. And that's not because the PD, again, is a bad lawyer. It's just because there's only so many hours in a day, and they can only handle so much in terms of how much time they're going to allocate to each case. So yeah, man, no, it happens all the time. And like that was my point. Like, once they entered their pro bono appearance, it was as if Rick handed them a big pile of money and said, you're my lawyers. Yeah. So just think of it like that, like pro bono, because that was on them, but they also knew, like, the concept of them entering their pro bono appearance, if in fact they were not planning on going to trial on January 8th, would have been mind blowing, because like a case like that kills the rest of your practice in terms of, you just can't take on other business because it takes up all your time. Like, you can't in good conscience just keep churning cases in. All your resources, because you're not going to, I mean, you can't do it, So, but in light of the fact that we knew that they were going to be ready to go to trial in 2 months, it made it completely plausible that they could come on pro bono, I mean, and then they could handle the case. They were ready for it. So, yeah, and that changes the analysis. It just does. It's like, if you're an appointed counsel, there's established case law that says, I mean, it's tougher to get, to get what they're asking for when they became, in terms of choice of counsel, as far as Rick Allen goes, because, they're basically saying you just don't have that choice when it's appointed counsel, even though there's the continuity argument, which is the fact that these guys both, had worked 1,000 hours on the case and were, obviously ready for trial. And, they had clearly made and created a attorney-client relationship with their client where he felt comfortable with them. He wanted them to be, his guys. And so when you get this thing where they're taking off and then they come back and say, all right, we're going to do it. We're going to do it on the arm for you, Rick. And he's like, oh my God, that's unbelievable. Thank you. And then that became his counsel of choice. And it moved it out of that appointed attorney area into paid counsel,
Yeah.
same as like he just hired them. So yeah, I'm dying for this thing to get up there. I'm dying for the argument. And I really hope that, cause it's got like this case, what people don't understand is that it's grown beyond just Delphi, Indiana. It's now taken on a national significance. I mean, whatever's going to happen in Indiana, whichever way the court ends up going, the high court there, I mean, it's going to certainly set the precedent moving forward for every other case that ever happens in Indiana and in terms of removal process of the attorneys. And clearly, like I had people that are much more in tune with Indiana law because I don't practice there. I'm a Chicago lawyer and Illinois lawyer, and our laws are different in every state, but these guys are like, there just was nothing in the statutes that authorized her to do this, and there was, so like all these things have to be sorted and they'll be sorted hopefully in a way that benefits the defendant. Not just in this case, but in all cases, because ultimately the way that we consume true crime content, we're all victim centric. We all very much care about the victims. We all want the victims to get justice. We all feel that way. But the part of the content that we're actually engaged the most into is the trials. Like that's what, and that is all about the defendant. It's really not about the victims at that point. Like what it shifts. I mean, it's always under the umbrella of getting justice for the victims, but specifically a trial is about the rights of the defendant. Like, so that's what we have to concern ourselves with during this period of time. And I've said it once, I've said it a million times. I mean, any victim is not getting justice if one of two things happens. One, if they end up arresting and convicting the wrong person. Under no circumstances is that justice for the victims because the person who committed the crime is still out there.
Yeah.
That's not justice. And secondly, is if the case gets so screwed up during trial that the poor family that had to relive the worst day of their life, probably for weeks, sitting in that courtroom, is now going to have to do it again because it got screwed up the first time. So those are two primary reasons why we care about the constitutional rights of the defendant and why we want a fair trial and why we want to get it right the first time. So, like I'm super anxious for it, as I'm sure many of our listeners are. I mean, it's a big deal. It's a big deal.
What kind of dynamics would this create? Let's say they do get reinstated here coming up on the 18th of January. Still got Gull there. I mean, then literally you have the defense counsel that she's been kicking and screaming and saying, no, you can't be here. And suddenly the Supreme Court says, guess what? Guess who's coming back to court? That is going to be a little uncomfortable, I would think. And that's going to be another thing to be watching.
Awkward. It's going to be super awkward. Yeah.
Extremely.
Yeah.
Extremely.
Yeah. Well, so look, the way this thing can shake out is it can shake out where they flat out deny it. Okay, no, you're not coming back on the case. We're keeping Gull on. Take care. Have a good day. They could do it where, okay, we're gonna reappoint you guys as public defenders so you can get paid for it, but we're keeping Gull on the case, and good luck with that. Or they could do it where we're reappointing you guys. We're taking Gull off, and we're going to appoint a new special judge, which is what they asked for. Mm-hmm. So if that happened, that means that they won completely.
So that will be argued as well coming up here in January, the new judge.
Yes.
Not
so
just,
the three.
Yeah. Okay.
Yeah. So the three things that they asked for are a trial be set within 70 days of the opinion, that Gull be removed and they be reinstated. So, I mean, like theoretically, the court could do a combination of it. They could say, okay, we're going to take you, like in your scenario, or they could do it where they say, okay, we're not going to go so far as to say we're going to reappoint you guys. Okay, but what we are going to do is we're going to send it back down to the trial court. We're going to appoint a special judge for this particular hearing, and we're going to force y'all to have the hearing, the DQ hearing of the two attorneys, so that you make a record. And so you can put it out there why you DQ'd these guys. And that's like, those are basically the four things that can happen.
Yeah.
And, I mean, or it could be a combination of, I mean, like the one where I just don't see how they can keep her on if they're keeping them on, because she's just, I mean, you always hope that judges, and it's their oath to remain impartial. It's their job, literally. But she's just put too much out there to where any ruling on any motion that goes against the defense, automatically the public is going to think that she's just biased, whether or not it was legally right. And so it's like, and you can't undermine the public's trust in the system like that. You just can't, like everybody's be like, this thing stinks, but pretty much every legal scholar that I've spoken with, and myself included, believe that if they don't reinstate these guys, it's an automatic, like this trial would be a practice run, that it's an automatic, it's structural error, and that it's going to get kicked back and it's going to get retried. So, I mean, like all those things are running through the justices of the Supreme Court's head when they're trying to figure this mess out. So it's fascinating, really. And it's sad for the girls' families and the victims, because, sitting there, like not having the knowledge of what the heck is going on with this thing. Cause they don't, like, lay people don't understand it. If they watch content and listen to content like ours, they do that for the reason to hopefully gain some more understanding of what's happening, which is why we try to do what we do, but like, I don't know if they're doing that, so it's got to be terrifying sitting there like, what is happening?
Sick of the ads?
We are too.
Start listening with no commercials now and get access to all of our episodes in advance of everyone else.
Become a True Crime Today Premium Plus subscriber on Apple Podcasts.
Search True Crime Today Premium Plus on Apple Podcasts or go to our podcast page and sign up now.
True Crime Today Premium Plus.
Sign up now.